Hi, I'm Tim Duggan, a lawyer with Horlick, Levitt, Lella, LLP. Welcome to this week's edition of HLD's Case Law Corner. This week I'll be discussing the court's decision in Toronto Standard Condominium Corporation number 1724 and Evdassin. This case dealt with Kitec piping, which most of you watching this will likely have heard about or dealt with at some point. For those of you who are not familiar, Kitec was a brand of water piping that was widely used in residential construction from about 1995 until about 2007. It was popular because it was inexpensive and it was easy to install, but its use was discontinued after it was determined that it was prone to leaking and causing catastrophic flooding. Not a great thing for water piping. This led to a massive class action lawsuit in both Canada and the US that was settled several years ago with the creation of a fund of more than $100 million to pay for claims. Now, why is this relevant for condo corps? This is relevant for condo corps because many corporations were built with Kitec piping if they were built during that time period. Needless to say, catastrophic flooding does not go over well with condominium insurers for high-rise buildings. Most insurers are not fond of that risk, and so most condo corps, in the interest of avoiding complications with their insurance and complications with the building flooding, are replacing their Kitec piping as they find it. Condominium buildings that are built with Kitec piping that discover this fact almost always require the piping to be replaced. In the case of piping that's in the individual units, and that is the responsibility of the individual unit owners, the corporation will typically implement a building-wide program to have the piping replaced, and may give the owners an opportunity to make their own arrangements if they don't want to participate in the corporation's building-wide program. So the case that we're discussing today, the TSCC 1724 case, the corporation was built with Kitec piping, it discovered this fact, and it implemented a building-wide program to have the piping replaced. It gave the owners detailed information about the program, about the estimated cost, about the plumbers that it proposed to use. And when it came time for the work to be done, and Mr. Evdassin, the respondent's unit, he refused to provide them entry. The corporation tried to get in again. Again, Mr. Evdassin refused entry. Ultimately, the corporation had no choice, it felt, but to bring an application pursuant to Section 134 of the Condominium Act to seek Mr. Evdassin's compliance. So the issue for the court was whether the facts of this case presented a basis for the condo corp to move forward with a compliance application. The court was satisfied based on the evidence that Mr. Evdassin had breached the act by refusing entry improperly. The court was satisfied that the corporation's request for entry was reasonable in the circumstances, having regard to the corporation's duty to take steps to avoid damage to the building. And the court held that it was reasonable in the circumstances to grant an order requiring Mr. Evdassin to grant access to the unit at such times as may be required on at least 7 days' notice to allow for this work to be done, and ordered him to not interfere with the corporation's trades in carrying out this work. They also ordered Mr. Evdassin to pay the costs of having the piping replaced, and ordered that these monies could be added to his common expenses. Now, the corporation did also seek some other relief in the application, having regard to Mr. Evdassin's other behavior in the building. And while the court held that his conduct toward the property manager that was occasionally abusive or harassing was contrary to the act and the corporation's governing documents, the court was not satisfied that it rose to the level of requiring a separate court order to address that. So the interesting part of this case is that it's one of the relatively few reported cases to deal with Kitec piping in condominium buildings and the interplay between the corporation's obligations to take steps to avoid damage to the building and the individual unit owner obligations to address issues in their own individual units. This case confirms that where there is Kitec piping in the building, the corporation is within its lawful rights to enter the unit to address that issue, and that addressing the Kitec piping issue is in fact a proper exercise of the corporation's powers. Mr. Evdassin was clearly the author of his own misfortune here. He could have simply provided access to the corporation if he had wanted to do so, and by failing to do so, he will presumably be subject to a substantial cost claim from the condominium corporation. That has been this week's edition of HLD's Case Law Corner. Thank you for watching. Don't forget to join us every Wednesday for HLD's Condo Law livestream on YouTube.